Marriage. Marriage is what brings us together today. Marriage, that blessed arrangement, that win a dream and love, true love, will follow you forever and ever. Welcome everybody. Welcome everybody. I wanted to put this on with Christina for like 15 years. Basically, the idea was, there's so much family law in this country, but like, what about family law issues not in a family law context? So this is what we are going to attempt today. There is obviously a lot of other contexts for which I couldn't find speakers, but I think we are going to be a little bit funnier than the last one was, as good as that presentation was. That was a very serious subject, and we are not that serious. Well, when we are in court, we are very serious, obviously, because we are zealously representing our clients, yada, yada, yada. Okay, so if you don't know me yet, I'm Marta Vanegas, and I'm a Deputy Attorney General practicing mostly employment law and employment-adjacent things for the Department of Justice. And I got an email. That's not the email I need. I have bios for my beautiful, wonderful speakers in no particular order. Let me introduce you to Luis M. Montes, the principal of his eponymous firm, with the main office in Walnut Creek, branch offices in Alameda and downtown San Francisco. Luis's clients depend on him to remove the dread of legal process. I don't know how he does that, but okay. He frequently encounters the crossover issues of family law, trust and estates, property and probate, while representing closely held businesses and their owners. He also enjoys mentoring and guiding new entrepreneurial attorneys, such as myself, emulating attorneys that helped him start his practice 16 years ago. A fun fact, Luis is one of 11 competitive flycasters to score a perfect score in the trout fly accuracy game in the American Casting Association tournament. This sentence has no meaning to me. But
he throws bugs accurately.
That is perfect. Yes.
But why would you want to do that? Okay, I assume that the trout and the bugs have something to do with each other, but ugh. Okay, our next one is Corrine Bielejeski. No, Bielejeski. There it goes. Everybody say it with me. Bielejeski. Yeah. And then we can say Bielejeski-esque. Esquire owns East Bay Bankruptcy Law and Financial Planning in Brentwood, California, because there is no Easter Bay than Brentwood, California. She served as law clerk to the Honorable Edward D. Jalen, retired in the Oakland Bankruptcy Court before entering private practice. She's a CEB Update author, co-editor of the Contra Costa Lawyer magazine, yay, and regularly speaks on bankruptcy issues. She's also super knowledgeable about a bunch of other things. It's so weird. Fun fact, Corrine is a big ham and played lead roles in several musicals for the Earl Warren American Inn of Court in Oakland. Next up is Christina Weed. She has been practicing tax law for 15 years since we started to plan this presentation. She has earned her LLM in taxation at the University of San Diego after finishing her law degree. Out of the more than 266,000 attorneys licensed to practice law in California, she is one of the less than 300 attorneys certified as a tax specialist by the state bar. Christina assists individuals and businesses with tax disputes, including income tax, corporate tax, other tax, this tax, that tax, property tax. Such a list. She also assists foreign individuals and businesses with their US tax compliance, and she's also a musical theater aficionado with me. Yes, these are my friends. Pamela Woodside has over 20 years of experience practicing law and has served as second chair in jury and court trials as well as arbitrations. She practices before all state and federal courts in California and all employment-related regulatory agencies. Before joining Littler, Pamela was Assistant General Counsel, Labor and Employment Law for a Fortune 200 retailer. She has some tips on this one, shopping. Before going in-house role, she spent 18 years in private practice focusing on labor and employment, including EPLI, professional liability, lawyer malpractice defense, as well as defense of architects and real estate professionals, and complex commercial litigation claims. Fun facts. She has 3 dogs and 2 cats. You add it up, you get 5. She also traveled 5 times cross-country. Maggie Grover has been practicing employment law in California for nearly 40 years. So she started when she was 10. Okay. She comes by her gray hairs honestly. Maggie has all employers too, I think. Maggie has represented and advised both employers and employees. She enjoys working as a neutral mediator, investigator, trainer, and expert witness. And she was an expert witness for years. She was killed. So good. Her passion is making sure that both employers and employees understand their rights and are treated fairly and with respect. Maggie is an unnatural athlete. That's her word, not mine, okay? Although she has no natural talent, that's again her word, not mine. Maggie is a competitive rower and is training for both the AIDS ride and the hike to the top of Mount Kilimanjaro. Isn't that K2? No? She's looking for anyone willing to climb Mount Diablo twice with her. So we go up, come down, go up, come down. I'm not gonna do that. I go up and open a gallon of wine and then have somebody bring me down. Okay, that was the intros, and now I'm going to pass the torch to our first speaker, Bwings.
Thank you.
Can you hear that?
Yeah.
Awesome. So when I fly cast, no bugs are hurt. The only thing really that gets hurt when I'm competing and fly casting is my ego. I'll tell you a big reason why it's my ego. Right now, the best accuracy fly caster in the world is a 22-year-old young lady who just graduated from the University of Washington. And she used to compete on our team, so we were always at our club. It's a great compliment to be told you cast like a little girl. She was 15 when she won the first world championship. Okay. So I came to family law very early in my career, about 16 years ago, and I practiced quite a bit of family law. I don't so much anymore, although I will take a family law divorce if a significant part of the case is a marital property business and is going to be addressed in the divorce. So I've gotten quite a bit actually of experience trying to address those issues. And one of the background is that and I represent mostly small businesses. In fact, in preparation for this, I only have one business that is in more than the scores of millions of dollars in revenue. Most of them are businesses that you would see around the neighborhood. However, those small businesses do provide almost half the jobs in the country, and because when they're owned in a marriage, as we all know, California has a 48% divorce rate. This comes up frequently. the magic in trying to take care of these divisions of marital property businesses is in the what I call the contracts, whether it's an operating agreement, the bylaws, buyouts, prenups, and the challenges that come with those. Really the biggest challenge that I have seen in trying to be proactive in at least mitigating the dread of the business divorce is to get the parties that are involved to come in and talk, get their own attorneys. Here's an example. Quite some years ago, I represented a startup. Startup had, I'm going to make up numbers, it's not local, but they're around. And so they had X number of founders. Once the business got going, we needed to buy some of these I'm going to call passive investors. And so we went through a lot of trouble and a lot of expense to buy some of these founders, and what we ended up was with 3 principals. At that time, they had just graduated from college, so as I remember it, one of them had a steady girlfriend and the other 2 were single. So the years go by, and one of them is contemplating now getting married. This was a corporation that I didn't form. It had already been formed. There was no buyout agreements in the bylaws. It was just basically a very raw corporation. And so they called me up because they were aware that somebody could get divorced, or now we're bringing in spouses, and they were these gentlemen were now of an age where they were thinking about getting married and starting their families. And so we called a meeting, and I was tasked with drafting buyout agreements. And of course, after the one gentleman got married, we asked him to talk to his now fiancée about addressing some of these buyout issues in the future should they get divorced. I'll shortcut the story is that over several months, a long time, they were unable to come to the table. And I subsequently was no longer representing them because in a board meeting, we were addressing the dangers of what if one of them, number one, died. It's unlikely that mid-20-year-old men are going to die, but it happens. And then, of course, at this time, they're all contemplating marriage, and as a family law attorney, I know that marriages are going to occur right between the 7 and 10-year mark, and then they're sprinkled throughout. And that could cause a lot of disruption in this business that's owned by 3 individuals, and now their spouses. And then they were bringing in investors, but that's a different conversation. To date, and it's been more than 10 years now, none of them are divorced, but they're all around 10 to 12 years of being married. So I think they're lucky because that hasn't happened. But I do deal with businesses where it's all of a sudden pops up in a divorce that we have to figure out how we're going to buy out the outspouse, the spouse that doesn't work in there. So that really, I find, is the biggest challenge, is to be able to bring in the in-spouse and then the out-spouse to address these issues. These are very uncomfortable issues. You're as a married person or a person that's about to be married. Oh, and this applies to prenups too. Another conversation, and that one is worth talking about. To bring them in, because now you're raising issues of death. You're raising issues of divorce. You're raising issues of trust in a very fundamental and basic condition of living and being married. It bears talking about prenups. Everything that I just said about the other thing applies to prenups, although they're a little bit more intimate because now instead of having a group of shareholders or owners, now you're just talking about two spouses. What I find the hardest about that is that breaching that discussion with first your client, that you have to tell him or her that, you know, there's a 42 or 48% probability that you're going to get divorced, and we need to address that. And how do we go about drafting a very complex contract that has a lot of timing in it, and it has a lot of language that you have to follow strictly if you want it enforced in 14 or 15 years. That's also very difficult. The other issue with regard to that, a very practical issue, is to assure that the other, the person that you're not representing has representation. And that is also a very delicate and difficult emotional decision. Sometimes, most of the times, it's not really an issue of cost, although that has arisen in my practice, where I call the other spouse or about to be spouse can't afford representation, and then how do you figure out how to do the third party fees? That's very important. Let's see what. I'll refer to my notes. And I do have a handout with some materials, but I'll give those after Marta tells me that I'm done speaking.
Yeah, that's going to be a while.
I'm used to it.
I have patience. I'm a married woman. I mean, certainly.
Well, I'm learning patience. I'm still single, but I'm learning patience. Here's another difficulty from our side as business lawyers and family law lawyers, is that when we are in law school or when we are practicing, we get to practice, or we're educated in family law, or in my case, business law. But one of the things that we're not educated in when we're in law school is, how do you counsel parties in really the emotional side of getting them in to address these issues. I'm pretty sure that almost everybody in here is a really good lawyer, and we have some control over our clients, but how do we get them in to have these really difficult and intimate conversations that are enmeshed in emotions? Yes?
I have a question with the overlap that you experience. If you have a couple who is married going into business together with one or two other parties who are obviously not part of their marriage, so that's not legally possible, is there do you take other aspects into consideration there for the share that couple gets versus, do you need to take into account their community property or even their prenup when creating those business agreements, or do you just treat them like independent members to the business contract and let it all fall out otherwise?
I'll tell you what my experience has been. So you have, number one, once there's a marriage, you're in business whether you like it or not.
Yeah.
Okay, it's the community property aspect. So really, where the share of the community property arises is in the shareholder agreements or the governance documents of any particular business, whether it's the operating agreement, the bylaws, or buyout agreements that should exist. So let's just say that this particular marital community owns a quarter of the company, and that in the businesses that I represent, it's very possible that somebody owns a quarter of a company. These aren't huge businesses. So the considerations that you have to take is, I did another presentation, is the accidental owner. The 25% couple, let's make it easy for my math. The 30% couple gets divorced. So without other considerations, one spouse now owns 15% and the other spouse owns 15%, if that's how the ownership, the shares are going to be divided. And that's a very good question. Please remind me to talk about the equitable considerations of the family law lawyer, because that's very important. So now the out person who hasn't worked or isn't part of the original ownership now owns 15%, and that could be more than the business or the other owners are able to buy out. Generally, in these small companies, you just can't go out and sell 15% of Acme Manufacturing like you could sell 15,000 shares of IBM on the open market. So that really limits the liquidity of it, which brings into play your imagination and creativity as lawyers of, what are you going to trade for that 15% that's going to make it so that the out spouse will give up that 15% in exchange for, I'll be flippant, the cabinet topper. Okay, and those are things that I've never done a cabinet topper, but we've traded away this so that we don't have an accidental owner who may not be well-versed in managing and running the company or making decisions. That's really important. Here's another reason that it's really important to have these, to think and really analyze and try to look in the crystal ball as to what's going to happen in the future. So let's say that you have an entity that has spelled out how we're going to buy out the outsource, and they're getting divorced. The family law court, in its equitable powers, has the ability to override what you paid your attorney, thousands of dollars to write up, and you've been relying on this because imagine Louis the lawyer that removes the dread of the legal process, really went through and thought it out, but the judge says, no, that's not equitable, and we're going to put that aside and we're going to divide it in another way that is more equitable. That I've not experienced that, but I know that it has happened.
Can the judge do that if both spouses were parties to the original contract though? If it's not just community property that they agreed to divide it up?
Let me answer her question first. Yes, the judge can do that. And here's the issue, okay, here's the issue. Let's just say that you are dead certain that that judge's decision was in error. What do? You appeal. Can these parties or this party afford to do an appeal? That is always a very practical consideration is, yeah, you may be right, 101% right, but now you have to bear the expense and the process of appealing, which goes back to even being more careful about that. I'll answer yours and then I'm done.
Suppose both parties have been in alliance with those documents, those agreements for years. How can the judge suddenly say, no, these documents are fair? There's been actual alliance by both parties. I don't know. Next question. Do you ever use revocable or irrevocable trusts for this marital property, that the property is 30% shares of equivalent trust? Corporation or the company is the trustee, but the parties that get benefits, they don't own them anymore, but the trust, they own them only in the position of being beneficiaries.
So this is how I will answer that. I do not practice trust in estates law, and I have ran into the situation where the owners put an interest in a trust for son. Son gets married and then gets divorced. That's like us hitting the lottery. If the money is there to litigate, because it's going to get litigated. So I've already gone over my 1 minute call. I'm going to hand out my handouts. Anybody has any questions regarding this? Because this is really a complex situation. I have my telephone and email at the bottom of this. Thank you very much for attending.
Okay, not sure why I'm here, but they wanted a tax lawyer. Oh yeah, you said you couldn't get that in the other speakers.
$299 or too stupid to call.
Okay, so I'm really just going to talk about something called innocent spouse, which is in the Internal Revenue Code, section 6015. And so let me start by describing a client. Many of you here, probably all of you, have had to deal with, married persons at various times in your practice. So picture, and I'm going to say a wife, because that's usually what it is, although I have gotten innocent spouse relief for a husband before. But you have a wife, she's been raising the kids 20 years in the house, she is a stay-at-home mom, she has not worked, and her spouse owns his own business. Come to find out, years later, she gets a tax notice in the mail. And it says that she owes $500,000 to the Internal Revenue Service. And she doesn't know how that's possible because she's doing all of the labor at home and she's making sure everyone gets where they need to be, and she doesn't know the in and outs of the business. So for that type of scenario, and the one where I had a husband get innocent spouse relief, he was not English speaking and his spouse was. But for that kind of scenario, the Internal Revenue Service has said, okay, if you meet certain criteria, we will say that you are an innocent spouse. And I know California is a no-fault state, but for purposes of tax, they're the innocent one. So under 6015, if you meet certain criteria, you can be relieved of this liability. Now, why do we care about this? Because if we file a married filing joint return, we are jointly and severally liable. And we as attorneys know that means they can collect $1 of that $500,000 from me, or they can collect all the $500,000 from me. We're jointly and severally liable. So the first criteria that you have to think about when you're thinking about an innocent spouse case, and these cases come to me a lot when someone's in the middle of a divorce and the skeletons start like creeping out of the closet. You know, they have this huge tax bill, they don't know where it came from. The first thing you have to think of is their jointly filed return. Because if there's not a jointly filed return, we don't have an innocent spouse case. There are some other potential remedies if you file married filing separate, but that is not a criteria for the innocent spouse cases. So under section 6015B, the first one, innocent spouse, you would request this on IRS form 8857, California form FTV 705. I'm mostly going to talk about the federal side because California usually piggybacks onto whatever the IRS says. So if you file innocent, it's called innocent joint filer with California, they'll say, oh, are you filing with IRS? Yes. Can you send us every notice you get? So you just keep keeping them in the loop, and they'll just kind of wait, and a lot of times they'll piggyback onto that. So I'm just going to speak from the IRS standpoint. So you have to file your innocent spouse request no later than 2 years after the IRS tries to start collection. So what does that mean? That means you're getting notice. You're getting a claim from the IRS. You're getting notice that they're going to levy you. You're getting a notice they're going to lien you. So you are aware that you are in active collections. You have 2 years from that point to file for innocent spouse. So one of the problems with innocent spouse that can come up, though, is that the IRS has to let your spouse know you filed. And so what does that make us think? We're thinking there's divorce, maybe it's not a great situation, maybe it's not that safe. There's no exceptions for domestic violence. You file an innocent spouse request, your spouse is informed, and they have an opportunity to participate in the case, object to your request, what have you. If you get a bad decision from the IRS, they're denying your innocent spouse request, you do at that point have 90 days to petition the tax court and appeal that decision. I have had innocent spouse cases where we're appealing to the tax court and the spouse doesn't disagree that his wife is an innocent spouse, and so he'll intervene in the case and even say, yes, she's an innocent spouse. Doesn't always work, but if you have a situation like that where one spouse is ready to take responsibility for it, that can help. A lot of notes in there. So in order to meet the conditions, you must file a joint return, as I said. You must have an understated tax or a tax due. You can show that when you signed the return, you did not know and did not have reason to know that there was an erroneous item on the return. And taking into consideration all the facts and circumstances, it would be unfair to hold you responsible for that tax liability. And some of the factors the IRS will look at to determine if it's unfair, or did you receive a significant benefit? If you're living in a mansion and have Chanel bags and a Maserati and your husband's reporting $30,000 of income, you received a benefit, there's a good chance that you're not that innocent. Sometimes if your spouse deserted you, whether you have been separated or divorced from your spouse is a factor. And then whether you got can I hold your question because I have so much to get through. Okay, thank you. Whether you received a benefit, like I said. Okay, so the second way, and this is under 6015C, is you would basically have the tax allocated between the spouse. And what we're looking at here is The requirements are that you're no longer married or you're legally separated or you've lived apart for at least 12 months. So basically what we're saying is you've been living apart, right? So how would you know on this most recent return that what your spouse's income was if you're still filing jointly? Because you can still file jointly until you're divorced, right? So this one is more of an allocation. We're gonna look at the return. We're gonna see like what amount should you actually be liable for, what part's not. It's not like a forgiveness of everything, because if you have any underreported income, you would still be responsible for that. For that. Okay, and then finally, and I only have about 5 more minutes, and this was the biggest thing for innocent spouse when it happened in like 2012, 2011, is they had 6015F, because if you remember, I said, you have 2 years from the time they start collection to file your request. Okay, but wait a minute. There's a 3-year assessment period for the IRS. What if I don't make the 2 years? What if I don't even know yet? And then there's 4 years if there's a substantial understatement to assess. And if there's fraud, there could be 6 or more years. So why am I limited to the 2 years? So 6015F said, we will give you equitable relief if you qualify. The conditions that you must meet to get equitable relief are you're not eligible for innocent spouse because of the 2 years, you filed a joint return, you timely filed your claim for relief, you and your spouse did not transfer assets to one another, you did not knowingly participate in the filing of fraudulent return, the tax that you are seeking relief from is attributable to an item of income from your spouse, so like that his business account or whatever that you don't have knowledge of. And the factors that the IRS will look at as well is what is your marital status. If you're still married, they say it's neutral. If you're not married, that sort of weighs more in favor of relief. Economic hardship. If you don't have an economic hardship, again, might not weigh in favor of relief versus if you do. You don't have knowledge or reason to know. And the example they kind of use for that is, say you know that you do owe $10,000 and you pay $5,000 of it, red check, you pay $5,000. And you take out a loan for $5,000, tell your spouse, pay the rest, and he goes off and gambles with it. Is it fair to hold you responsible for the money you thought was going to pay your tax? So there's situations like that in terms of knowledge. Did you get a significant benefit? Are you now compliant with the tax laws? We can't say we're an innocent spouse if now that we're on our own, filing our own returns, we still don't file on time, we still don't report everything, we still don't pay everything. There can be exceptions for non-payment if you don't have the money to do so, but you need to do everything you can to be as compliant as possible. Oh, and then one last thing, we have 2 minutes. One last thing is that there are exceptions for domestic violence sometimes. So, for example, if you had knowledge of what your spouse was doing in terms of his or her taxes, or your wife was doing in terms of her taxes, but you are so afraid because of domestic violence or some other spousal abuse that is going on, so you sign it, and you're just, you don't really have any other option. You're doing what you're told, you're scared, you're fearful for your safety. Those can be an exceptions to like the knowledge requirement that you didn't have any knowledge. And with that is my speedy version of innocent spouse, and there's a lot more. I skipped over a lot, but I don't want to take over anyone else's time.
That's good.
Well, the question I was going to ask is, you were talking about if you received a benefit, i.e. if your spouse is very clearly understating their income because of what you're experiencing, would that same kind of thing apply if they're earning a really big income and you're oh, well, we're living in opulence because you make so much money, babe, but they're understating it by a certain amount that is that about knowledge, or is that about is it about knowledge? If someone's earning $6 million versus $4 million, it might not read to a spouse if they're not in charge of that.
I think my response to that is if you're filing a joint return, just because you're a stay-at-home mom or stay-at-home dad and your spouse is the one who works, doesn't mean that you get to sign under penalty of perjury without reviewing your return. So yeah, the idea is, if I have all of this decadence around me and I'm supposed to review this return that I'm signing under the penalty of perjury, I need to review it. If I see a number that couldn't possibly it, how can I sign that in good faith and say, oh, I didn't know? I hope that answers your question.
I think it does, because it's not about whether or not it's like a low number versus if it's reasonable for you to believe that that was true. It seems like what it is.
It is a reasonable person standard, like what a reasonable person would they have known.
Okay, my question is, the spouse is so evil that he or she, they are opening the mail and hiding the 2-year notice from me. So I don't even know that there is this connection against me personally. Do I have then some relief from the 2-year period from when I have actual notice of this connection?
Yeah, remember I got all excited, went back to 2012, was like, hey, they have 1615F now, we have equitable relief, and I was all nerdy with my tax law. Yeah, so if you miss the 2-year deadline and something like that, that's a good fact. Like, I haven't seen any of the mail. I don't get the mail. It goes to my P.O. box. My spouse gets it after work every day. Yeah, you might be a good candidate for relief under subsection F.
Okay, good. Yay.
Is there something you need to know about your marriage?
I opened the mail.
All right, I'm gonna set my timer, and that'll be my reminder to stop talking, because I, as you know, am a ham. All right, so I've got some poll questions for you, and don't worry, I'm not going to call on you afterwards, but I just want to get a feel for how much you guys know. So first off, who here has heard the word bankruptcy before? All right, we're starting out pretty well. Second question, how many people know the difference between Chapter 7 and Chapter 13? Okay. And then, how many of you have looked at or know about the state court exemptions in CCP 703 and 704? All right, I knew Anne was going to do all of this. All right, okay, so thank you. That helps me kind of figure out what stuff to go into Marta. Can you guys hear me okay, or do you want me to move closer? All right. So first off, bankruptcy is a federal procedure. We're in the federal court. Everybody in Alameda and Contra Costa counties goes to Oakland Division. You know that gorgeous federal building? We're across the street in an office building on the 2nd and 3rd floors. They're still pretty nice, but we're not over there. We use mostly federal law. That's in 11 USC. And your materials that you'll get from Sarah after the MCLE Spectacular concludes, you'll see a couple of code sections that are going to be your VIP sections. But we also use state law sections like California Code of Civil Procedure 703 and 704. So the way that creditors do their collecting, right? You guys all go out, you get a judgment, and then you try and collect. And under state law, I can use CCP 704 to protect my stuff. I can protect my home using the homestead, and I can protect a tiny bit of equity in my car. And starting about a year ago, I can now protect the first $2,000 in the bank account. So in family law context, you can take them all the way down like that. But for normal creditors, you can't take a certain dollar amount, which is tied to the poverty index and all this other stuff. But for your guys' purposes, it's about $2,000. For bankruptcy purposes, we get to pick and choose. So we can use CCP 704 to protect our house, or we can use Section 703 to protect our stuff and only a tiny bit of equity in a house. So if you've got a Harley, you're picking 703, and if you've got a house, you're picking 704, and if you have both, you're kind of screwed, but we'll get into that in a second. All right, so bankruptcy cases are separated into different chapters. Chapter 7 is what most of you think about when you think about a bankruptcy. That's that quick in, quick out chapter. It gets rid of your credit card debt, your medical debt, and your old taxes. Not the last few years, but the older stuff, as long as you did things correctly. If you have a house, you have a car, it's all or nothing. You gotta keep everything the same way it was before, and you keep making those payments and keep your stuff, or you give it all back. That's when you turn in the car or hand in the keys for the house. The other chapter of bankruptcy is Chapter 13, and that's what most individuals will file in Contra Costa County. Well, it was a little bit more before the homestead laws bumped up. Now it's probably about even. And that's a repayment plan. So let's say that I file a bankruptcy and I'm running a business and my income fluctuates. I might do a Chapter 13, and that allows me to repay some of my creditors back, but not all of them, and still get that discharge. Show of hands, is anybody in here a family law attorney? No, okay, fantastic. I don't have to tell you about getting your attorney's fees then, so we'll skip that part. There are also other chapters, Chapter 11, Chapter 12, Subchapter 5. Those are all for businesses filing a bankruptcy or for an individual who owes too much. But they're all repayment plans. So the only difference you need to know of is if it's a small number, 7, it's usually a white out. So what chapter you can qualify for depends in part on something we call the means test, and that's how much you make. So for this hypothetical, I have a lot of debt. And Marta, my dear sweet Marta, who I love, and who we're gonna get married, does not know this. We each earn $60,000 a year, and if I go out and I file a bankruptcy and I don't tell Marta about it, well, good news, I earn less than the average for a household of one, and I can go in and file that Chapter 7 before we get married, and everything's gonna go nice and wonderfully. But if I don't tell her and I file the bankruptcy after we get married, even if she doesn't file jointly, now our income is over the average household of 2 in California, and now I can't file that 7. And instead of doing a 3-year Chapter 13, I'm stuck in a 5-year plan. And I kind of have to explain to her at some point why her name showed up on a bankruptcy petition and why a trustee is asking for her pay stubs. The general rule is if you've got somebody who's in debt, you want them to file the BK before they get married. And this is true even if there's a prenup. This rule about disclosing both parties' income is all across the U.S. It's not a community property thing. You have to include all of your assets, all of your debts, and you have to include your spouse's income as well.
And debt.
So only if your spouse files jointly. So if your spouse does not file jointly with you, their debts are not included and they are not going to be discharged. So it's only their income and the community property. So a big thing right now is an inherited IRA. Thank you, families. So if you inherit an IRA, that's your separate property. But if you move all that cash into a joint bank account with me, Marta, because you love me so much, I know, my creditors are going to eat it all up. And so that's probably going to lead to a divorce, but that's a later hypo. So under Section 522 of the U.S. Code, all of the debtors' community property and all of the debtors' separate properties included in there. And under a case called In Re Mantle, the site's in your materials, the first person to file the case gets to control all the community property. And where this comes in is if there's a community property business, because Marta and I, we started a law firm together, and it's our baby. And you know what? The entire thing comes into the bankruptcy. And I get to make the decisions about what happens about it. Same thing if it's a house. I get to decide, we're going to keep it or we're going to sell it. Yeah, and this is the point at which she decides she's filing for divorce, right? But under this In Re Mantle case, let's say Marta is sitting on some debt too that she didn't tell me about. When she files her case, doesn't matter that they're both in active bankruptcy, my case still controls all the community property. And unless there's community property left over, it's all going to go to my creditors and not to hers. So what about that?
Can I ask a question?
Yeah.
So couldn't you theoretically manipulate the system and have the person with the less debt file first, and then the second person who has more debt theoretically there, and in that hypo
so
where
community property, whatever's left from the first case, then moves over. So we're talking about whether there's assets left afterwards or not. The other thing is under 703 and 704, that homestead is joint. That car exemption is joint between the two of us. So if we file our own cases before we get married, we can each protect $7,500 of equity in a car. If we file a joint case, it's $7,500 total for all vehicles in the marriage. And that includes if you are separated, but or divorcing, and the community has not been separated yet. So it's a very real marital penalty. And most of the time, you know, we get married so we can use their income, right? I mean, that's not why I married you, Marta. But there's a very real penalty.
So she says.
But the other thing is just to remember, is the spouse actively working in the business? Is it community property or is it separate property? Was this Marta's business beforehand and I moved off of her? Because I did. Or is this a true community property business? And that's for the fight for the family law folks to have. But for bankruptcy purposes, we have this presumption that everything is community property. So show of hands, how many of you heard about the Inri Brace case that came down a few years ago? Excellent, most of you don't know. I love talking about it. So the Inri Brace case came down from the Ninth Circuit in 2020. In that case, we're gonna use our facts again. We are married and Marta finds out I have crappy credit. So Marta goes out and gets our home loan and she puts the house just in her name and she takes it as her separate property. And I'm totally fine with this. I signed the quitclaim deed and everything. I'm like, that is fine. And it's all in your name, we're good. Under Inri Brace, there is no title presumption in California anymore for a divorcing couple in family law or for bankruptcy purposes. So unless there is a separate writing where I said, oh, sweetie, I understand that this would be half my property and I am willingly giving it to you. That house that is in her name on title is not her name. The only exception to this now is in the estate planning context. If she were to pass away, then the title presumption still holds and it would be her separate property. But for bankruptcy purposes and for dissolution purposes, it is treated as community property. And so what people are looking for is that text message, that email, that writing that says, I knew that it was community property and I willingly gave up my interest. So how this happens is that I go out and I file the bankruptcy because it's great, she owns the house. We don't have to worry about it at all, except the trustee does a title search because I have to disclose the name of anybody I've been married to in the last 8 years. And lo and behold, when she puts up my address, it turns out that my spouse owns it. And then it becomes property of the bankruptcy estate. I don't always use my money well, so I wanted to file my bankruptcy and protect my Harley that I have paid in full, $50,000 asset. And you know what? I've used Section 703 to protect that Harley because I'm protecting it using that wild card. And I am very excited about keeping my Harley. Marta, my non-filing spouse, gets to say, nope. Pursuant to California law and bankruptcy code, a non-filing spouse has to give permission for the filing spouse to use 703. She's going to require me to use 704 and protect the equity in the house instead. And my Harley goes bye-bye. That makes me very sad. But that's my problem for filing bankruptcy in the first place and not telling my spouse about it. There is a new wrinkle to this. If somebody's been separated for a number of years and they can't find their spouse and there is no community property house, there's no longer that requirement to not be able to file under 703 and protect the stuff rather than the house. But in R1, clearly she's just filed divorce and she has the ability to step in and block what I can claim. How many of you have heard about the Barton-Werper versus Buckley case? Came down last year, U.S. Supreme Court case? A couple of you? All right. It's very rare that a case will come down from our local court. I actually know the judge and both of the attorneys involved in this case. So, any of you here do real estate? All right. So, this is what happened. A couple, before they got married, bought a house together. And in this case, I'll be the bad guy again. I know how to do construction law. and construction, and we get married later on. We decide to sell this property in the Bay Area, and I decide, you know what? Instead of doing the extensive repairs that are needed, I'll just do a patch job, and then we won't disclose it. It'll be great. I'll just say the house is perfect. And we end up divorcing, or at least file the dissolution paperwork after we sell the property, and we get sued. Because it turns out that I did not fix up the property, and Marta doesn't know anything about it. And we go to state court because we're sued, and they hold that this was a joint venture, and therefore both of us are guilty of fraud. Marta is super pissed off at me, and she goes out and she files her own bankruptcy to try and get out of this huge debt. And she says, hey judge, this isn't fraud, this isn't non-dischargeable, this should be discharged. I didn't do anything. And it went all the way up to the US Supreme Court, and they decided that under California's reading of a joint venture, this did qualify as a joint venture, and because every court is bound by decisions made in other courts, they were bound by the California determination, and unfortunately, Marta does not get a discharge of this debt in her bankruptcy. And I will tell you what is so unique about this case. The actual Supreme Court decision, the judges say that they are sorry. How often do you see that? So, and apparently this lady is super nice. Like I said, I know the attorney. So this was a local case out of San Francisco. If you're ever interested in looking at joint venture or in advising clients on real estate, why they shouldn't be idiots, that's the case to look at for failure to disclose. The other thing I want to let you guys know, because this happened recently, if until the community property is divided by the family court, right, the whole thing comes in the bankruptcy estate. I had a case that concluded at the very beginning of this year, and we were actually able to get a move-out order. I was able to, I know, right? I didn't even know it was possible. So it turns out that there's a federal code of civil procedure where if you're selling a property in bankruptcy court and your spouse, who's the in spouse, is not playing along with the sale, and they are actively opposing it, turning people away for inspections and for for visits and things like that, you can force them off the property. You can force a move-out order, and you can get an order that says, even if it's community property and both your names are on the deed, that only the debtor has to sign all the paperwork. Only the debtor can make the decisions. And this was very, very extreme. And the facts in this particular case, the house would have been foreclosed because the in-spouse wasn't making the payments, and the out-spouse, who was my client, could not afford to pay for his rent and the property. But I got a phone call about it recently, so apparently it's now gotten around to family law attorneys. I did a program on it with the family law bar and Shannon Wolfram, and now I'm getting phone calls like, can you kick my spouse out? So anyway, kind of, maybe yes, in really unique circumstances, and we can talk about it. Anne?
In that case, was there an underlying ouster?
In the family court case, no. My client had a restraining order, but he was the out-spouse, not the in-spouse. There had been dueling restraining order petitions. My client won, but at that point he had already moved out. The other fun thing is this is the only case in my career, and I've been an attorney since 2006, where I had that Matlock moment, that TV law moment. The other side admitted to breaking into the property after she moved out. She said, oh no, I just went in through the doggy door. My client had drywalled over the doggy door, and so he had pictures of the broken drywall. So she had actually filed a declaration stating that she had gone through the doggy door, and I was like, wow. It was fantastic. It's just lovely. And because it's not happening to me. If it was happening to me, it'd be absolutely horrible. But the facts of this case were very extreme. And so in the family court context, to get a move out, both parties have right to the house during the family law action. So the court doesn't care if you're just divorcing, unless there's domestic violence, you get to both stay there until the house is sold. So really, this was a unique action because the house had to be sold in order for the Chapter 13 to go forward. These sort of move-outs are more common if a debtor like me files a Chapter 7 and I don't want to give up my house and then I'm being difficult, then the trustee can kick the debtor out. Obviously, I've put myself in front of the court and they have jurisdiction over me. But to get this one, it was the first time for me, and it's a really fun case for me. All right, I know that was bankruptcy in like 5 minutes. Well, actually 17 minutes. But if you have questions, my info is on the materials, and I'm happy to take a question now before we go. All righty, we're on to our employment law folks, right? Yes.
Can you hear me? Yeah. So shifting gears a little bit, I do employment law, so we're going to talk about relationships in the employment context and the fun stuff that causes. In looking at relationships and the problems and issues it can cause in the employment context, I was looking at some statistics, and they said about 36% of people actually admit to engaging in dating relationships actually in the workplace, which is a little surprising to me. Well, maybe not so surprising considering some of my cases. But obviously this can cause a host of problems. What I found more remarkable is, a lot of times those relationships don't last. About 60% of them don't last. And of those 60%, the vast majority, even after they break up, they continue to work together, which can cause even more problems. For employers, which is predominantly what I do, I've done employment defense for the vast majority of my career at this point. But there was a point in time where I was a plaintiff's attorney. And so I'm going to give you just sort of a little example of why an employment case, a dating relationship in the workplace can be such a pitfall for an employer by this one case that I handled when I was a plaintiff's attorney. And obviously, the different levels of relationships can be a problem. So you looking at either supervisor-subordinate relationships, which are usually the most fraught with peril, co-worker relationships, and sometimes usually dating up, or supervisor, an employee dating their supervisor, or someone who's dating a subordinate, which is, it's problematic. But in this particular case, although it was considered allegedly a consensual relationship, it was an individual who was the secretary for a man in a financial organization. She was not the best performer. And I guess in a way, to make her feel better after she received a bad performance review, they went out and drank a lot. And needless to say, this continued, and they would continue to go out and drink a lot. A relationship developed. They would, back in the day, it used to be AOL Messenger, so like AIM message, now it would be Teams, so they would be chatting back and forth all day, these very obviously personal, romantic relationships. One little important fact I should mention is this guy also had a fiance. So at some point he decided that his in-office dating relationship was not all that great, and he decided that he really was going to dedicate his time and attention to his fiance, which made his secretary very, very upset. And so she lost her mind, is the best way I can describe it, and embarked on this campaign of sending him progressively threatening messages as to how she was going to destroy his life. She sent them when she was at work, she sent them via email, she called and left them on his telephone. Now again, this was my client. And
And eventually, her job performance deteriorates, and she is ultimately terminated. And she decides to sue him for sexual harassment. Except, he has photo evidence of her in these very provocative positions, wearing lacy underwear that she sent to him. And she also has a series of voicemails where she has said that she will stop suing him if he will just continue to date her. That did not go well for our case, at least the sexual harassment component. However, the lawyer that I worked with, who had been doing it for a while, came up with a really great idea. He turned it around. He basically said it could not necessarily have been a consensual relationship. He was her supervisor, and therefore, even though it seemed like they were going out for drinks consensually, she felt pressured to do it. And when the sexual harassment case was not going so well, he then turned it into a gender discrimination case to say, well, they were both involved in this romantic relationship. She gets fired, he retains his job. And that actually worked really well. And so we ended up getting a fairly significant settlement. Maggie's probably not surprised by that.
The great thing about employment law is it's always got juicy examples. And I think that my practice attracts the weirdos.
Oh, that was my point.
I was going to say, I think I can beat you both. And it's not,
Private practice.
and actually my in-house life was a little bit more exciting than private practice, and I cannot, it's very surprising. But anyway, so this is why employers generally take very seriously whenever employees get into a romantic relationship. It's not like they want to invade your privacy, and they don't really so much care about the relationship, they care about their own liability, because under California law, if you have a supervisor dating a subordinate, you can have strict liability if they sue for sexual harassment. Which means they just kind of assume that the employer knew about this whole thing, and it becomes a very hard and onerous case. So,
Can I chime in here?
go ahead.
One of the things, the other thing that California law does, is this on? Okay. It imposes on the employer an obligation to take reasonable steps to prevent sexual harassment. And employers take that seriously to a point where I think they drive relationships underground. I have seen employers that say, thou shalt not date anybody in your work environment. And you're spending 40% of your waking hours at work. If you're single and they're single, that may be a budding relationship. And so you start dating and you hide it. I've seen policies that say, if you start dating somebody, we will relocate somebody, which only works if you are a company of a certain size. I've seen policies that say, you need to advise us if you are in a consensual relationship and sign a contract that says you will advise us if you break up so that we can monitor the situation. And that's what some employers think is protecting them and complying with the requirement to take reasonable steps to prevent harassment.
Yeah. And I mean, Maggie brings some very good points. When I was in-house, I worked for a company, and the company bought out another company, and they had two very drastically opposed viewpoints on dating in the workplace. So on one, it was absolutely forbidden, and it was, you have to tell us, and we're gonna try and separate you. It was a Fortune 200, so it was possible to separate, though we did have issues with that because it was, why are you asking me to move and not the other person to move? This seems discriminatory, so it gave us many more headaches, even though we thought we were trying to resolve this situation. And then the company that we purchased just had a different view and said, well, it's kind of private, it's their relationship, we don't view it as a problem. Even to the extent where they said, a supervisor dating a subordinate, we don't view that as a problem. Yes, yes, that was fun. We don't view that as a problem, and so we're not going to do anything about that. Whereas the other company had a very hard line. If a supervisor dates a subordinate, the supervisor is going to be terminated. And that was obviously to protect us from sexual harassment claims. So it became a very difficult situation to manage. Good question?
I hear and so that's what they think protects them. Is there any way that you've seen that like a contract or waiver or informed consent form or anything like that actually works?
My take on it is that you have a good policy saying that unwelcome behavior is forbidden, period. That you have a good opportunity for people to have dialogue. So that if you are in a situation where it has become untenable for you, a case that I have had was dating relationship. He was the supervisor. He kept saying, I'm going to break up with my wife. And then he comes in and says, oh, my wife is pregnant. And she says, oh, well, we'll just continue working together. And he said, oh, no, we will continue sleeping together and beat her up. But, yeah, well, but that's a small company and he was the owner of the company. If you have a good human resources department or even a good CEO or an ombudsperson who can open the door and have that dialogue, that goes a long way, and training.
Yeah, I would agree with that. And I agree with Maggie's earlier point, it depends on the size of the company. I was doing an employee handbook for a company that's a smaller company, and I was talking about no conflict of interest and their dating policies. And one of the policies sometimes people come up with is an anti-nepotism policy. And that's just even for greater family dynamics. You can't have a father who's a supervisor of their child, or a mother who's working for the son, etc. So that there's not any issues with favoritism, things of that nature. And when I addressed this and I brought this up saying, we should probably adopt some sort of policy, they said, we can't do that. And I said, why not? And they said, because pretty much that's how we get our employees. We depend on the husbands to bring their wives, to bring their kids, to bring the cousins. And they said, it's word of mouth among families and they all come. And so we have a lot of family relationships. I said, okay, well, how about just not having them in direct supervisory relationships? And they said, we can't do that. And I said, okay, so I'm just now going to advise you what the law says. I recommend training. I hear what you're saying. And I'm just going to advise you on what the risks are in the future should something happen. I get your business. It is a risk, though, that you have these family relationships and you have families supervising each other.
I have a question though. So I see this on TV all the time and I always yell at the TV, please explain to me why I'm right. Unless it's a supervisor-supervised relationship, these relationship contracts are actually hurting the company. Like, I should not know if two of my employees who are near co-workers are dating, because otherwise I have knowledge and now I'm responsible for a harassment.
I think you can craft them in a way that says, I'm entering this relationship voluntarily, it is consensual, and if it becomes no longer consensual, if I want to get out of it, I will let the company know. So that you've got, hey, I've agreed to this, it's not unwelcome conduct.
Right, and I'm aware that they have an anti-harassment policy. I know what the anti-harassment policy is. I'm familiar with what the avenues are if it becomes a problem. And yes, it's consensual, and if it becomes non-consensual, I will let you know. And so it does add some protection, because as far as the company knows, it's a consensual relationship. We're not getting in your business. You are aware that we strictly prohibit any sorts of harassment. You are aware that we have avenues. So if it becomes harassment, you know the avenues to go to complain. And then if it becomes a problem, you let us know, and we will as Maggie said, take reasonable steps to prevent any sort of issues with harassment.
You're using a term I've never heard before, unwelcome behavior.
That's really the opposite of consensual. It's, if I want to get into a relationship and we're teasing back and forth and flirting, it is deemed to be welcome. If I am flirting because my boss thinks that I should flirt, then it is unwelcome. And it is unwelcome conduct that is the basis of a harassment claim. But I always tell people when I'm doing training, don't rely on that. I have seen so many cases where you end up with taking the deposition of the person who is claiming harassment, and they were joking and they were participating in all sorts of things. The pipe fitter who laughed loudly at the wet t-shirt contest until she was under the spigot, all of that. Then they say I was coerced into doing that. I was coerced into participation by my colleagues and my supervisor who had power over me. And harassment is largely not about sex. It is largely about an imbalance of power. And so this welcome, unwelcome is an element of proof. I want to talk a little bit about the unwinding of relationships, because that really affects the workplace and can affect the employer and the employees. This is a horrible statistic, and I haven't checked it in a couple of years, but it used to be that murder was the #1 cause of death of women in the workplace. And most of those were from a spouse or former lover. So one of the things that the employer has to understand is what protections they can put into place, like getting a restraining order and some really basic security protections when there are concerns. If somebody is coming to work exhausted, potentially black-eyed, missing a lot of work, male or female, you need to have a way of opening that discussion to find out what protections do we need to put in place. Are you okay? You can't pry too deeply into their personal life, but you don't want somebody going postal within your work environment because they have a grudge against somebody who is one of your employees because he broke up with him. You tend to find that even in your garden variety harassment cases or relationships gone south, that employees line up on one side or another. This character is the best worker. Oh no, this character is the best leader, and you may end up having to help unwind the relationship to keep your workforce engaged. And that's another problem that I have run into a few times.
I have a question for you. Have you ever run into a situation, as I have, where you have two workers' relationship that unwinds and they both get a restraining order against each other?
I have, yes, only once. In that case, one of them was really annoyed that he had to give up his gun.
Amber and Johnny?
Amber and Johnny. And I think that going back to the contract, one thing that a contract or a policy can do is set expectations for the participants and for your coworkers. So you've got a policy that as things unwind, you can point to and provide training on. We do not tolerate inappropriate, unwanted abuse of power in the workplace. And you have all known about this relationship. It's not going on anymore. If you see something, say something. We want to make sure it's a comfortable environment for everyone to work in. And so having those contracts or those policies does help in one. And a couple of really off-the-wall things. because I get them all. If you have an employee who dies, the law says that the wages that are owed and any accrued unused vacation pay goes to the surviving spouse. But sometimes they haven't changed the information in their personnel file, and the surviving spouse listed in their personnel file may not be the real surviving spouse. So if you are changing your life relationships, go back to your employer and let them know. Most of the time you see it in an employee handbooks. And if things change, let us know. But I think that's something that really should be discussed, and a lot of times the supervisors will know, oh, Jane's getting remarried. And they might go to Jane and say, hey, talk to HR, get this updated.
That's actually a very important point. When I was in-house, we had that happen a couple of times where where our employee died and they had remarried, but the old spouse claimed that they were entitled to the money, and they had a contract which they had the old spouse named, and it became this battle, and they wanted to involve the company. We're like, we're not going to do that. We had like lawyers coming at us to say, it's that person's money. No, it's that person's money.
And as a baby lawyer, I had to do an interview in that situation, and it was in Stockton. And I swear I was the only female I saw ever when I was in Stockton. And I was so hometown. All I want to do is give the money to the right person. That's all I want to do. But I got sanctioned for asking who the right person was in interrogatories. So that one still burns me. And then the other thing is on the benefits plans. If you have a 401k, make sure that those beneficiaries are updated. And talk to your employees about making sure that they're not giving their passwords to people that they don't want to have access to their funds. I dealt with a situation where the employee had named his daughter as a beneficiary of his 401k. His goal was to establish a fund for her retirement, or for her education. When he died young, unexpectedly, and the baby mama, after he died, got his phone and drained the funds out of the 401k. Now, the employer knew the person had died, probably should have shut that off. But this woman should never have had the ability to get that. So there are things that the employer can do to protect the assets of the employee and understand some really practical situations where it's going to get real.
I'm sorry.
No, I like questions.
Well, items that, you're putting policies in there, and I'm assuming that most of the employees of these companies are backbone employees. Does the signing by the employee of these waivers and disclaimers and stuff ever create contracts that initiate or have those habits?
Most employee handbooks have in multiple locations, in the front, in the middle, and right where you sign, the at-will language. It says nothing can change the at-will language. And I don't believe that it does. And at-will can be eaten up by exceptions. And if you let somebody go based on their gender or based on having complained about sexual harassment, those are things that would vitiate the at-will nature, because those are unlawful reasons. Any lawful reason to terminate is fine, and unlawful reason you have to get the at-will done.
What duty does the employer have to verify that the beneficiary designation is a valid one? Like the example of somebody going in and making changes to the password, particularly after the employee has passed away.
So usually there's a trustee on those accounts. So the employer technically would not have responsibility, but I was representing the daughter in that case, and I took the position that the employer, knowing, should have notified the trustee so that the account was not drained. And I also said that after the death, there was no lawful use of the password because that account could not have been used by the person that was the employee.
So what happened?
I'm sorry?
So what happened to the
They
daughter?
paid the entire balance to the daughter, didn't pay my fees. It was a settlement. And I took it because I wanted the daughter to have an education.
Thank you.
Question? No? Are we done?
I have some flow charts up here just to help you issue spot. For instance, spouse, if you want one, you can take one and